Welcome to Cool as a Cucumber, How to Testify Successfully at Your Deposition or in Court in a Utah Domestic Relations Case, Part 3. Your deposition or testimony can rarely, if ever, do anything but hurt you. Believe it, a deposition is taken for several reasons. It is important to realize what a deposition is and is not. A deposition or testimony that you give is not taken to exonerate the person being deposed or questioned. It is not your opportunity to tell my side of the story, or to get my licks in, or to set the record straight. Accept it. Simply put, with rare exceptions, so rare as to be insignificant, virtually non-existent, your deposition testimony can only hurt you. So do your best, honestly, to minimize the damage. Don't let a lack of preparation do you in. Repeat, your deposition and testimony can rarely, if ever, do anything but hurt you. This means you don't try to make your deposition your personal soapbox. Don't even think about it. Don't. I really mean it. I really mean it. You're not an exception. Why you are deposed. One of the reasons you're deposed or questioned is to learn your version of the facts. That is, to learn what you will testify to at trial or a hearing if you were called as a witness then. This will enable the deposing attorney to better prepare his or her case for trial or hearing. 2, another reason is to develop impeachment evidence and admissions against your interest. The attorney deposing, that's the term for questioning you in your deposition, will attempt to elicit testimony favorable to his or her client, which is thus damaging to you. If your answers to the same questions you were asked in your deposition are materially different from those questions when asked at the trial or hearing, the attorney will read back portions of your deposition taken previously and try to impeach you. That is to say, make you out to be a liar. 3. Most important, a deposition is not the time or the place to tell your side of the story. Not a chance for you to set the record straight or your chance to take cheap shots at the opposing party. People who disregard this sage advice end up coming across as arrogant, petty, and too clever by half. And they get burned. You are no exception. Ignore this advice at your peril. You have been more than fairly warned. At the trial, your attorney will ask you questions, both in direct examination and in cross-examination, to bring out your testimony in a favorable light. While it may be frustrating to restrain yourself from telling your side of the story or setting the record straight at the deposition stage of litigation, it is essential for a successful deposition and favorable resolution of your involvement in the lawsuit. Think of it this way, too. The deposition is for the judge, not for you. Give the judge what the judge needs to know, not what you want to yammer about. The deposition process. A deposition is taken in an informal setting. It is usually in an attorney's conference room, but it can be taken elsewhere. There is no judge present. Your attorney will be with you while you are deposed to make objections to any improperly posed questions. There is plenty of water to drink, typically, or accessible to you. If you need to get up to use the restroom, you may, without having to ask permission, although you do have to tell them, I need to go. You simply say to the attorney questioning you, I need to be excused to use the restroom, or something like that. The attorney or attorneys questioning you may appear to be very friendly. Do not be fooled. The opposing attorney is looking for chinks in your armor to stab you in the soft underbelly, no matter how charmingly he may slip in the knife. Power struggle. At the outset of a deposition or questioning, the examining attorney will attempt to establish control. This can be done in several ways. An attorney will often try to befriend you through small talk or humor before and during the deposition. Do not be fooled. Remember, this is an adversarial system. The opposing attorney is never your friend. Never. Another way the attorney questioning you may attempt to establish control is through intimidation. If you are prepared for your deposition and questioning and are familiar with the ins and outs of the process, you will not be intimidated, or at least not be so easily intimidated. If you're unsure about any aspect of your deposition or testimony, then please, for your own sake, talk to your attorney in advance. Once you're in the deposition hot seat, the time for preparation has passed. For good. Don't worry about looking foolish or unsophisticated with your attorney. Your attorney's purpose is to educate you and polish you up. Use the help now when it matters. No question is too silly to ask your attorney, and no silly question is more damaging than the one unasked when it could have done you some good before you're in the hot seat and have nowhere to turn. Questions unasked are questions unanswered. That is to say, they are unanswered until the opposing lawyer asks them and you look like a deer in the headlights, or worse. Ask in advance your stupid and embarrassing questions of someone who's looking out for you, please. Admonitions at your deposition. Your deposition will typically begin with the deposing attorney explaining the ground rules of a deposition to you. These are called admonitions sometimes. If you are unfamiliar with these, you will be relying on the opposing attorney for an explanation. The attorney is therefore in control and may be misleading you. To avoid this, it is important for you to understand the rules before the deposition begins. The following is a typical list of admonitions that are often given by the deposing attorney at the beginning of a deposition. After each explanation is given, the attorney will ask you if you understand. For example, the oath you have been given is the same oath that would be given in a court of law and comes with the same penalties of perjury. The court reporter is taking down every word that is spoken. The reporter cannot transcribe nods or head shakes. Also, a court reporter can only take down what is being said by one person at a time. I therefore ask that you wait until I finish my question before you give your answer, and I will provide you with the same courtesy. Your attorney may make objections to my questions in the course of your deposition, but as you can see, we have no judge here to sustain or overrule objections, so, except in rare situations, you will need to answer each of my questions, regardless of whether your attorney objects to them or not. If you do not understand a question, please let me know. If you do answer my question, I will assume you understand and answered the question I asked. Please do not guess in response to my questions. I am, however, entitled to your best estimate in certain circumstances. Do you understand the difference between a guess and an estimate? Your testimony will be transcribed into a booklet form or a written form. You will have the opportunity to review your testimony and make any changes you deem appropriate. You will then sign your deposition transcript under the penalty of perjury. If you make any substantive changes to your testimony, however, either your attorney or other counsel may comment on your changes at trial, and it may adversely affect your credibility. I therefore request you give me your best testimony today. Is there any reason you cannot go forward with providing your testimony today, your best testimony? Are you under the influence of any drugs, alcohol, or medications that may affect your ability to understand and respond to my questions? Do you have any questions regarding the deposition process before we start? Listen to the particular admonitions that are explained to you by the opposing attorney. Be confident, however, that because you watched this video series before your deposition, and well before your deposition, not in the car on the drive over, you already have an understanding, a clear understanding of the deposition process and are ready for the challenges that lie ahead. Thanks for watching or listening, and we'll see you back here for the next part